Who Owns the Code? With Richard Hundhausen and Brad Frazer.
The Azure and DevOps podcast is a show for developers and DevOps professionals shipping software using the latest in .NET, Azure, AI, and DevOps. Listen on to learn how to increase quality, ship quickly, and operate well. The show is sponsored by ClearMeasure, a full-service software architecture and engineering firm. Find them at www.clearmeasure.com. And now your host, Jeffrey Palermo.
Welcome to the show. I'm Jeffrey Palermo, your host for helping you and your teams move fast and deliver quality and to run your software with confidence in Azure, all while using everything that the .NET ecosystem has to offer. I'm really excited for today's guests. I have two guests, Brad Frazer and Richard Hundhausen. And Brad is a Boise, Idaho-based attorney and partner at Hawley Troxell, which is Idaho's largest law firm, where he leads the intellectual property and internet practice group with a specific focus in IP strategy, AI, data security, and IT. He's a graduate of Brigham Young University, UC Hastings, and the University of Utah. And he has decades of experience in cybersecurity, internet law, IP, the list goes on. And he's also had roles as Deputy General Counsel at major technical firms. And he's also a published novelist and a recognized expert in emerging technologies like blockchain, NFTs, and Web3. And my other guest is a returning guest on the podcast, Richard Hundhausen. He helps software organizations and teams deliver better products by understanding and leveraging Agile and DevOps and Scrum. He's a professional Scrum trainer and the author of the book Professional Scrum with Azure DevOps from Microsoft Press. And as a software developer and consultant with over 30 years of experience, he understands that software is built and delivered by people and not just by processes or tools. So, Brad and Richard, welcome to the podcast.
Thank you, Jeffrey. Pleasure to be here.
It was nice to be here, Jeffrey.
My pleasure. First, Richard, you've been on the podcast several times before, but for the listeners who kind of aren't familiar, you've been doing software for so long. What keeps you coming back for more?
The learning. Every time I sit down, I learn something new. I love AI because it's teaching me new ways to think about things, shortcuts. It's constantly critical of the code I write, and it's like having a pair programmer who never gets tired or goes to bed.
Nice. And Brad, unlike Richard, you don't code all day for a living, and instead you're in law. But what's fascinated you with the intersection with technology?
I don't code every day, all day, like Rich does, but I do have clients that code all day, and clients who build infrastructures and platforms and monetizable assets coding all day. And so what brought me to this intersection, Jeffrey, is the notion that my clients need to be able to own what they create in order to have a successful exit. My particular practice focuses on growing a company from inception to exit using intellectual property as the principal revenue driver, even beyond EBITDA and bottom line. My mantra is to grow a startup from the meeting in the garage to $20 million exit, principally using IP, intellectual property. And of course, that can't happen if they don't own it. And everything follows from that, Jeffrey.
Yeah. And that is really important. You both have done presentations on this topic, AI-generated code, the legal implications. And so just to give the listeners the synopsis, Brad, is if I'm using a tool to generate code as I'm delivering software and I check it in to get source control, is it clear who owns those new lines of code?
No. And as I like to say, Jeffrey, it's all academic until you get sued. Richard has heard me say that many, many times. And by that, I mean, you may proceed academically to write code, either using human authorship or machine authorship all day long. And frankly, no one will care until you try to go to sell your company or get an investment round or you end up in court. And then we care. So your question is a good one, but principally it remains academic until one of those things happens. But to answer it in a vacuum, you probably own some of that code. There's probably some sufficient human authorship in the code scenario you just described, Jeffrey, that you could say, I own some of this source code. Yeah, I believe that.
I think a lot of people just assume that if they're the one operating the computer and then something comes out of it, that they own the copyright, whether it's typing into a Word document, Microsoft Word saves a short story, or whether it's code. What makes it so confusing or nuanced?
If I may, let me ask my friend Richard, because he and I came up with this concept of who owns the code together. And so we've done seminars where Richard will take over the podium and actually write lines of source code using Copilot or one of those AI tools.
Right.
And if I may, Jeffrey, may we ask Richard just to describe that process just a bit? Richard, how have you and I in our seminars, how have you demonstrated code generation using an AI tool? If we may, Jeffrey, let's start there.
Please.
Yeah, absolutely. It's so easy to start with, say, ChatGPT and come up with a product idea, come up with a vision, come up with a goal, come up with, a backlog, epics, features, stories, however you want to do it, and then just have it start implementing it. I mean, honestly, you can know very little about coding and you can get something that is fairly decent. It may not be too deep or too wide, but something that can certainly come across as a valid product. And then, put it out there on the market. People use it. You get feedback. You continually improve it. And I don't know how much of that's going on today. I know a lot of the apps I'm writing internally that I don't plan to monetize and sell and exit from ever, Bradley, but it's all AI written. It can write PowerShell better than I can. I'll, of course, tweak it, comment it, prune it. But, I'm doing 5-10% of the coding at most. It's doing the rest of it for me.
And so, Jeffrey, back to your question. So Richard gives us a good example of coding using an AI tool. Source code is generated using AI. In a vacuum, in an academic vacuum, that's fine. But let's talk for a moment, Jeffrey, to better answer your question about a fundamental copyright concept. So Copyright is not a verb, as you know. Copyright is a noun. And specifically, a copyright, a noun, and here's the legal test. A copyright, a noun, is created when a sufficiently creative idea is reduced into or onto a tangible medium. That's a mouthful, but think about it. It's simple. Every time you, Jeffrey, take a picture, a copyright is created, period. Every time you, Jeffrey, a human being, sculpt clay, a copyright is created. Every time my friend Richard Hundhausen writes source code, a copyright is created, unless the authorship, the act of reducing it to a tangible medium, Jeffrey, is done by an AI. If that happens, then under current U.S. law, there is no copyright and there is no ownership construct. So you are right. If someone sits at a computer and types up a spreadsheet or a Word document, that's human authorship. The issue with AI is that the authorship is being eliminated in favor of the large language model randomly generating hopefully correct responses, right? And that's not authorship under the current U.S. law. It's all about authorship.
So let me take a few examples. For a long time, whether it be Dragon Naturally Speaking or these transcribe pieces of software, or even Siri, I can speak into my microphone and then the computer is listening to audio and putting down into words, and it may correct my grammar or whatnot. Does that meet the test for authorship?
It does, Jeffrey. And the reason is because there's a one-to-one correspondence between the inputs and the outputs. If I were to take your inputs that you spoke into Dragon Naturally Speaking and transcribe them, had a human being transcribe them, I compared them with the output from Dragon Naturally Speaking, they'd be the same. There'd be a one-to-one correspondence between your human spoken or authored inputs and the Dragon output. The difference here, of course, is that when you type in a prompt, there may not be any correspondence between the prompt, even if it's a natural language, English language prompt, and the AI output. And that's the difference. Somewhere between those two extremes, authorship is lost.
Somewhere. So, and I've used Copilot to say, create a method to query all of the employees in the database using the employee entity in the employee table where their birthday is greater than such and such. And it'll generate the entity framework code that's exactly in my brain, exactly as I intended it. I would expect that to be on the side of the line where I authored it because it just mechanically saved me keystrokes. Does that meet the bar?
It probably does. It probably does, Jeffrey. But again, remember, we don't actually know until a couple of things happen. And may I explain the steps in determining whether or not you've actually created a copyright? I mean, it's interesting to me. Oh, right. So in your hypothetical, you've created code, source code. And to be clear, it's only source code that is copyrightable subject matter, not object code, of course. So source code is copyrightable subject matter. So you have now used an AI tool to generate a body of source code. What are you going to do with it? Are you going to out-license it? Are you going to monetize it? Are you going to combine it with other modules or kernels and create it into a fully functional product and sell it? I don't know. But what I do know is that in order for you to have a remedy in copyright law to sue someone and make them stop stealing your source code, you have to have a thing called a registered copyright. And to get a registered copyright, you have to send a copy of the source code into the copyright office along with $65, $75, whatever it is. And you have to assert that there is sufficient human authorship in this copy of the thing that you're sending in, photo, clay, source code, to justify the copyright office saying, yeah, Jeffrey has written human authored source code here. We're going to give him a registered copyright. But you see, that it will be looked at by a human being who will pull apart your source code and will question you and say, Jeffrey, how much of this was actually authored by a human being, you see? And so we go down this path of you attempting to prove, whether it's to the copyright office or to a federal court judge, that you actually authored that source code. And it's a very, very loose test, right? And that's why I always say it's all academic until you get sued. But that's the test.
All right. So both of you, how have you found yourself advising software development groups?
So first of all, Jeffrey, your reaction was my reaction. I'm like, wait, what? It can't be like this. I just want to jump back for a second. One thing you can do is the human authored prompt. That can, that's human created. So you can get a copyright for that, but it's non-deterministic. You can't think of that as source code because it'll go in and get you something completely random next week.
Right.
May not even compile, may not do the same thing.
If I'm putting in a prompt and then I'm inspecting what comes back and then I prompt again and I'm fine tuning until I have exactly what I want. It's almost as if I have an assistant who's helping me form the clay and I'm looking at it like this and I'm saying, no, a little off of that, a little off of that. And I say, okay, now it's good.
That's very good, Jeffrey. And that, if you iterate that process again and again and again, eventually you have stripped away enough of the AI authorship that you will have human authorship. Sure. But doesn't that cause us to ask the question, then what's the value proposition in AI? If you're effectively having to strip away all of the AI content to create human content and have a copyright, what's the point? You see what I mean? And so that's one of the main things I instruct my clients on is you're all spun up about the value proposition in AI and the cost savings and vibe coding and how cool all that is. Okay, but if you have to iterate and iterate and iterate to strip away the AI content, end up with something that you can actually own and protect and monetize and sell, what's the point?
I think the point is being able to move in programming at the speed of the developer's brain. Because right now, even with the best tools, with ReSharper and the hotkeys and Visual Studio and all the great libraries, there's still a whole lot of mechanics that go into typing the right things and getting everything organized. But I have some kind of design in my head, some kind of picture in my head. Now, it's possible to set hands on the keyboard and not be quite knowing what you're going for. But most of the time, we have something in our head. And to me, AI-driven development is about shrinking the time that it takes to get the picture in my head into the files on the computer.
Do not disagree. Do not disagree with you, Jeffrey. The key is, though, at the end of the day, has that iterative process caused you to end up with something that the copyright law will consider to be human authorship? And again, nobody cares, Jeffrey, nobody cares. If you never go to court or you never sell your company or you never get a loan or you never have to out-license the software, think about that for a moment. I'm sure you've out-licensed software before, right? Any licensee is going to make you warrant that you own the code you're out-licensing, and you can't. if it's AI generated. You see the importance of understanding that granular issue of how much human authorship there is, even if you never sue, even if you never register a copyright, even if you never sell your company. At some point, Jeffrey, somebody might ask you to out-license the code and warrant that you have title to it. You can't.
Yeah.
You're committing breach of contract. The moment you out-license the code and give them that warranty, you have now committed breach of contract, and they can sue you, and we'll go to court and determine how much human authorship is in your source code. No kidding.
Richard, what do you think of this whole thing? Where's the line?
So do this: shape the clay. Have GitHub Copilot write the code. Make all the refactor, make all the changes, get it what you want, and then have one of your kids type in all that code again from scratch. Now,
Right.
now a human just wrote all the code.
Wait a minute. That's just like getting a book from the library and having them retype it, and now all of a sudden I have the copyright to it.
Richard's being facetious because he knows me well enough to know that, right? But go ahead, Richard.
No, we've done this presentation a few times, and we've fielded a few questions that are, you can smell the wood burning. People are thinking, well, how do I get out of this? How do I, because they're sitting on a bunch of code that was written by AI, and they're thinking, how do I do?
Every consultant out there, every person who works for a company on a contract basis, yes, there's a transfer of copyright from it's work made for hire contracts, and everything that I produce for you, I am giving you ownership of the copyright. And if it is that Copilot generates a line of code that the copyright can't transfer, from a practical standpoint, that's not a workable situation.
No. And it's not. And that's why now in every single one of my clients' independent contractor agreements where they hire somebody, whether it's to write code or take pictures, it specifically warrants in there that they're not going to use AI. Because, Jeffrey, if they don't warrant that, they have nothing to transfer. Nothing. So I can go out and sue all these independent contractors for breach of contract because they're going to send deliverables into my client that they don't own in contravention of a warranty that they have title to it. And my clients don't own it. They can't monetize it. They can't sell it downstream because upstream the contractor lied and said that it owns the code that it wrote using AI. It's a lie. So I don't disagree with you that it's not workable, but that's the legal environment we're in. So what do? I cause all of my clients to make their contractors warrant that they won't use AI and that they actually have title to the code. And if the contractor can't make that warranty, we simply don't hire them.
But you're making a blanket statement that would make sense if the line on the continuum of owning the copyright or not owning was very clearly on the side of AI authorship versus human authorship.
Right.
But our discussion is we don't know where the line is. So isn't it very possible that I could use Copilot all day long, but use it in a way where it's mechanically saving me a lot of time? I'm super productive, but
Sure.
By golly, I am authoring every bit of software that's being produced, and then I give it to the client, and I'm faithfully telling them, look, I built this software. I just used a computer to save me mechanical.
If you're comfortable ethically making that assertion in a contract, great. But when the wheels come off the bus and I go sue you for breach of contract, you'll prove in court whether or not there's sufficient authorship in that source code you delivered to merit copyrightability, Jeffrey. There's no other way to say it.
And I can understand a big ordeal and a headache, but it seems like until that's tested, we don't know where the line is because it's not been ruled on, right? Or are you saying the line is...
It's all academic until you get...
Yeah. Right. So it sounds like it's a risk avoidance posture versus a we know posture.
Very good, Jeffrey. That's exactly what it is. So Rich can jump in and say, as he writes code, he now knows, because he's heard me say this 50 times, he doesn't own a copyright in AI-generated code. And so, Rich, how does that maybe alter or modify your risk avoidance practices as a coder? That's a great question, Jeffrey.
It is a great question. And as a consultant, primarily I go in to help with process improvement, product development improvement. I'm not ever contributing to their code or their product development.
Mm-hmm.
So I don't have to worry about that. If me using AI helps build utilities and scripts and things that help make me a better consultant, that's an advantage, and it's not something I have to worry about as an ownership perspective. But my own personal things, sure, I'm working on some projects that someday might be productized, but now I have to rethink that. Fortunately, any kind of questions I have, I know somebody to talk to.
Yeah.
Carrying on this, extending this concept just a bit, Jeffrey, if I may. If I were a coder, and I'm not, but if I were a coder and that were my livelihood, as part of my scoping process and my due diligence on the client intake, I would say to the client, what are you going to do with this code? Is this just going to run resident on a server in the basement and operate the vending machines? Or is this something you're going to productize and try to sell for $1 million? It's kind of a key difference, right? Because if it's the latter, then I'm going to take much more care to make sure that my deliverables are copyrightable subject matter. If it's the former, I don't care. But if the client says, oh no, this is a bet the farm kind of a deal, this is the next app that's going to unicorn for $1 billion. Well, you know what? When I sign that contract as a coder, I'm going to make darn sure that I'm not committing breach of contract and that I'm delivering code that both I and the client can own. It's a continuum, just like you said, Jeffrey.
Okay. But there's a style of using Copilot where you basically say, hey, you're using Copilot to do what would be a find and replace. Find all of these instances and change it to all of that. And even before this generation of language model-based AI, there were find and replace tools. And there's IntelliSense where it's, you press the dot and it completes a word, or even drafts, 4 lines of code or entire methods. I mean, we've had that for several decades where code would just be generated. Now we just have a different mechanism by code being generated. So if your advice is don't use AI, it almost seemed like your advice is don't let the computer generate characters in the source code. If not, then I ask, where is the line that you're recommending?
So let's be clear. I never have ever told a client not to use AI, ever.
Okay.
In fact, I have a deck that I've shown 100 times. And the first slide in the deck, Jeffrey, says, use AI, consume AI, invest in AI. That's my first slide in my deck. Use AI, right?
All right.
My advice is not don't use AI, be a Luddite. My advice is to be cognizant of the fact that when you're using AI to write code, whether you're a coder or you're just a part-time programmer, is to be cognizant of the legal environment. 1, you don't own a copyright in the outputs. 2, you can't warrant title. 3, AI's hallucinate. You can't warrant the accuracy. 4, are you doing DoD contracting? Holy cow, you're going to get debarred. 5, what about HIPAA and PHI and PII? Are you compromising any of that? What about attorney-client privilege? If I enter attorney-client privilege into a prompt to write code, have I now lost the privilege? See, Jeffrey, it's the legal environment in which you're operating. It's not don't use AI. Use it smartly.
Okay, maybe I misunderstood. I thought you said if the contractor was going to use AI, don't hire that contractor. Make sure that you're hiring a contractor.
What I said is that if the contractor won't warrant that the deliverable was human authored, then I may not hire that contractor. That's a completely different issue.
Okay.
Right?
Okay. So if the contract, then what advice would you have for a contractor that says, great, I want to warrant and I need to warrant that it was human authored. Let me train all of my software engineers in how they do things to make sure I can warrant that. How should they think about that?
I know. Here's the answer, Jeffrey. If I was a coder in that situation, I would first go out and read Taylor versus Perlmutter, a federal circuit court appellate decision that talks about this exact issue, the copyrightability of AI content. And then I would go and read the three Copyright Office pronouncements on copyrightability of code. And then I would probably hire a lawyer. And I would say, okay, here's my business. I've read the 3 Copyright Office pronouncements. I've read Taylor versus Perlmutter. I now want to write code and I want to ethically, correctly sign a contract that says my deliverables are human authored. That's what I would do. There's plenty of guidance in law, Jeffrey, on how to answer that question.
Okay. I want to make sure I include that in the show notes. Taylor versus Kerdmeyer?
It's the case is Taylor, Thaler, with whom Richard is actually connected on LinkedIn and has traded messages with Stephen, Stephen, Taylor, Thaler versus Perlmutter. Perlmutter. That's the seminal case and the law today, Jeffrey, on the fact that there is no copyright in AI outputs. It's the law of the land.
So we have to answer the question, what is an AI output and what is just the computer being helpful?
So I've been thinking about that, and I'm just some guy in Idaho. But to me, for example, if I'm in GitHub Copilot and I type a line of code and then it goes, oh, I catch your drift, and then it prompts me to write 2 or 3 more just like it.
Totally.
How is that different than copy paste or using ReSharper? And the test I have, and this is not a federal case approved test, is it deterministic?
Right. Good.
Is it deterministic, or does its creative juices kick in, and the next time you do it, it does something different? And I know that's probably not enough to make Brad feel easy about it, but to me, that's the thing between like a ReSharper kind of AI versus a chatbot AI that says, write me some code that does this. I know there's a spectrum there.
Yeah.
Right. You know what I would do, Jeffrey? I've been thinking about your question, and it's a good one. I mean, you should have a lawyer who can understand and interpret Taylor versus Perlmutter and the Copyright Office promulgations or pronouncements for you. Okay, but as a practical matter, you know what you could do? You write all this code, and right before you send it off to your client, you can spend $75, which you can bill to your client as a cost, right? And send it into the Copyright Office, the whole thing, the whole source code body or corpus. Okay. Send it in with $75 and say, I want to register my copyright in this code, and go through that process with the Copyright Office and let them make a decision for $75 if you have added sufficient human authorship. Because if the Copyright Office says, yeah, we'll give you, Jeffrey, a copyright registration certificate in this code, that's pretty good. And I would be comfortable ethically warranting that this is copyrightable subject matter. Now, can you do that every single time you have a deliverable? I don't know. It's $75 and it's like 3 weeks out of your life to send it into the Copyright Office and say, hey, you guys tell me if this is copyrightable subject matter before I sign this contract. That's not a bad way to do it, frankly. $75 is less than I charge.
And of course, then you're already in the contract. Every week, contractors are committing and pushing code into their client's code base. It's just that's just the way they work.
Right.
So yeah, $75 a week. It's almost like you would have to do it in batches, almost like a back-end administrative process just for risk mitigation that says, sure, if ever you get sued and you get challenged, well, I've been registering the copyright so that the Copyright Office said that I have the copyright, and my contract says that I'm giving it to you. So here it is.
I kind of love that idea, Jeffrey. I think that's right. Right.
Oh, and of course,
either that, or as you are signing these contracts, warranting that you have title to the code you're conveying to the client, just speak to the client and have a candid discussion and say, look, you know the old saying, I can do it fast, I can do it good, I can do it cheap, pick 2. You've heard that, right?
Oh, yeah.
Okay.
Oh, yeah.
Say to the client, pick 2. And if the client says, I want it good and I want it cheap, or if I want it fast and good, then from there you sort of moderate the copyright issues. And you could say to the client, okay, I can do it fast and cheap, but I can't warrant title. See what I mean? I mean, there's nothing wrong with having a proactive discussion and saying, I'm aware of the copyright baggage that comes with writing code using an AI, but let's talk about that. What are you going to do with this code, right? What are you going to do with it? Do you need it fast and good or fast and cheap? I think that's an appropriate discussion to have, because that can help the coder, Richard, my friend Richard, sort of analyze how much due diligence he needs to do on the front end as he's writing this code. Richard, what do you think about that? I would have to do that. I don't know. I've never written code for a client. Richard, you have. How much due diligence do you do when you code for a client? Do you ever have that discussion? I don't know.
If I'm lucky, the contract says they own it when I'm done. That's about it.
Right. So I can say that all of our client contracts and the client discussions is you own it when you pay. And so that's the only stipulations. Like, look, if you don't pay, but you own everything that we produce for you. And I could see a standard consulting contract maybe getting a new clause or a new sentence or a new paragraph that says generative AI tools will be used, and the contractor does not claim to withhold any rights based on the workmanship, and everything that every copyright that would automatically be bestowed on the contractor is hereby given over to the client.
Right.
as opposed to the contractor
Right.
warranting something that may, hand waving may be contested somewhere later down the road.
It's a very elegant solution, Jeffrey. I like that.
It is.
And because I represent people who consume code more than I represent coders, my contracts will continue to say coder represents and warrants title to the code. But you, as the owner of a software company who codes and you have 30 coders working for you, you might very well modify your outbound contract to say just that. Like, I warrant whatever title that I have. Do you know what a quit claim deed is, Jeffrey? A quit claim deed. You know?
Do not.
Okay.
No.
Here's what a quit claim deed is. I right now can sell Richard the Brooklyn Bridge. Right now, I can sell Richard Hundhausen the Brooklyn Bridge with a quit claim deed. It says, it's a piece of paper and I sign it and it says, I convey to Richard Hundhausen all of my right, title, and interest into the Brooklyn Bridge. However, I don't warrant that I have any title to it. See, quit claim deed. So you could turn your outbound contracts into what are effectively quit claim deeds, saying, hey, whatever title we have in this code, we will convey to you on payment in full, but we don't warrant any title to it. You'll slide that by most consumers because they don't have lawyers like me looking at the contracts, Jeffrey, quite frankly.
Yeah.
And so you could slide that right by. Why not?
Now, from a practical standpoint, I think most contractors, well, let me just talk for myself. I know for my clients, we're very candid about what technology we're using and how we're using it, and trading with their software engineers tips for how to use it even better. So there's no mystery that it's being used. So it's from a practical standpoint, that doesn't seem to be the risk. I like the caution that you're bringing up that somebody at some point is probably going to challenge it, and that's the argument that they're going to make.
Go ahead, Richard, and then I'll comment. Go ahead.
I say that's the concern. I don't think too many people out there know this.
Yeah.
So contractors and clients, they're just going along, holding hands and dancing using AI all the day long. They haven't thought this through. It floored me a few months ago when Brad made it this clear. Who owns the code? The answer, you don't. I mean, drop the mic.
Right. So let me give you a real world example, Jeffrey. So a year ago, I was closing a deal for a client, a $20 million, not a huge deal, but $20 million, right? We were buying a software company for $20 million. And I was the guy doing due diligence for the buyer. Mm-hmm. Right. Oh, good luck, seller. Brad's doing the due diligence for the buyer.
Yeah.
Okay.
Yeah.
So during due diligence, I caused the seller to rep and warrant that it owned the code. Right. And because I'm me, I pushed back on that. I said, do you really? Do you really? Who's the human being that wrote this source code? And they say, well, we got it from a contractor in, I don't know, pick your country, India, China, Tallahassee, Florida. I don't know.
Yep.
So we went and we looked at the contract. And there was, of course, no warranty of title. There was, however, an assignment of copyright. There was an assignment, just like yours, Jeffrey. It says, we assign the copyright to you upon payment in full.
Yep.
But we dug down deeper and we found out that, in fact, the contractor had no copyright to assign. Didn't have a copyright to assign. And so what do you think that did to the deal value? Do you think I was going to pay $20 million to a seller who didn't own their code? It's not a rhetorical question, Jeffrey. Mm-hmm. The answer is no.
Sure.
You see?
Sure.
And so that's where it comes back to haunt you, is because now the seller's pissed off because a $20 million deal caved, and they're going to go back, and who are they going to sue, Jeffrey? You, because you delivered something that you didn't own. That's the problem. No kidding. So how's your insurance, Jeffrey? Do you have insurance against claims that you've breached contract? I don't know. Do you have insurance against claims that you've delivered something that you don't have copyright to? I don't know.
So what about the companies that say, I have employed W-2 employees are the only ones who've been working on this code?
We
don't know how they've done it, but how does that change it? Because they were just employees, but maybe they used Copilot, or maybe they didn't, or maybe we don't even know. What then?
Very good, Jeffrey. All that changes is the fact that I, as the buyer, am walking out of the room because you don't own it. The only thing that your hypothetical changes is who the seller is going to sue. Now the seller doesn't have a vendor to sue because employees wrote all the AI-generated code. It doesn't change the title construct at all. Seller still doesn't own the code. There's nothing for me to buy. I fold up my briefcase and I walk out of the room with my $20 million check because you got nothing to sell.
All right, so Facebook goes to sell Facebook.com, and, well, they clearly have a lot to sell, but then you ask those same questions, and let's say through examination of the records, they go file by file and don't have traceability down to who actually authored file by file. And it's like, well, a whole bunch of people did a whole bunch of stuff over a long period of time, and here's the source code.
Right.
I mean, that's everybody.
I don't know what to tell you, Jeffrey. It's a flawed model from a copyright law perspective. And so people are doing a lot of flawed deals, I guess. People are buying stuff. They're buying air. They're buying thin air. They're buying Brooklyn bridges, Jeffrey. How about that? That's our tagline. They're buying Brooklyn bridges because the sellers don't own the code. There it is.
Okay.
It's all true. But again, nobody will care, Jeffrey, until there's a lawsuit. I don't know how many times I can say that. Nobody cares until there's a lawsuit. And
nobody
then we'll
will
find out that nobody
else. Well, I can understand having someone make a warrant that they can't functionally make, but who could come along and say, you said that was yours? No. It's in fact mine. Who would assert that they own it and contest, let's say you buy a company and with it you bought some software.
Right.
Who could possibly come along and say, what? You just bought that software? You can't, because it belongs to me. How did you buy it?
Anybody whose website was scraped to train the LLM that wrote the code can sue you. Think about that.
Okay.
Do you know how and where that LLM was trained by which it wrote that source code? You have no idea. They don't tell you.
Because we don't have traceability to the source data, to the training data. And the foundation models aren't showing it.
The moment you take that source code that you bought for $20 million and productize it, somebody out there is going to look at it, buy it, decompile it down to the source and go, wait a minute, this is our source code. Look, go out to GitHub and look at the repository and see it's our source code. And you, the buyer, my friend, are going to get sued for copyright infringement. Absolutely, because I'll sue you, right? And what are you going to do? Who are you going to go to? You're going to go back upstream to the seller and say, oh, guess what? I guess I'm going to have to sue you now for breach because you really didn't own that thing and I got sued. Jeffrey, that happens every day. Every day.
That sounds like in the category of lawfare, where whether it's a valid claim or not, the claim is made and you're hoping, and they just hope for a settlement. Just to get
invite Richard and I back and we'll do litigation 101. I mean, I'm a litigator. I've litigated copyright cases for 37 years, Jeffrey. And if you really want to get into the nuts and bolts of copyright litigation, let's do it. But that's exactly what happens.
Yeah.
That's exactly what happens.
I'm going to take you up on that offer, by the way.
That's fine. But that's exactly what happens. Somebody sees a competitor with functionality that replicates some of their functionality. They don't have a patent on it, and I'm not going to bore you with patent law. And so they go, dang, the functionality of this compiled code is a lot like my compiled code. I wonder how that's possible. How did they just happen? Did they have 200,000 man hours reverse trying to come up with source code that replicates my functionality? Let's get a copy and find out. Mm-hmm. Right? So we get it. We reverse engineer it down to the source. We compare it line by line. We go bada bing. It's copyright infringement and you are getting sued.
That's a valid point. Any of the training data, and we don't know exactly which websites are used to train all of the foundation models, but we know that vast swaths of the public internet are used, and it's common practice for websites at the bottom to have, copyright such and such company, whatnot. Whether they've filed their text of their website with the copyright office or not, they put that notice down there. And it's almost like all of that text is scraped and purportedly to train the foundation models, but the full text of copyrighted books is not used to train the foundation models, citing copyright. What's the difference?
Oh, but it is, Jeffrey. Did you read the Anthropic case? That's exactly what Anthropic did. Anthropic scraped and copied and trained their LLM, Claude, on billions, millions of whole books. There's
the entire interior text. Okay. We'll have to include that one in the show notes too.
It's Bratz or BRANTZ or something, Bratz v. Anthropic. And Anthropic lost a big part of that lawsuit because, in fact, it just got certified this week for a class action lawsuit. Think about it, Jeffrey, a class action lawsuit for illegally copying the content, the whole content from cover to cover of millions of books. This is game over for Anthropic. I don't know if you're a Claude fan, but this is game over for Anthropic if they lose this lawsuit. It's a class action lawsuit.
Still ongoing. Wow. Well, I'm thinking some of the blog posts from the Microsoft product team is talking about how they're using Copilot to generate code that is being checked into the Microsoft libraries which is being released under open source licensing, which you have to have a copyright in order to, open that copyright and release it under a different license. To the extent the exposure that we're talking about, that would be one of the big companies that would hopefully have some court cases to sort this thing out.
Well, as you know, Microsoft is being sued because they bought OpenAI. And so Microsoft is being sued by a number of copyright holders because Sam Altman went out and scraped the internet for free and trained his foundation model of ChatGPT. Well, I'm sure you know, Jeffrey, there are at least 40 pending copyright infringement lawsuits going on right now, only one of which affects Microsoft, being sued by the New York Times, Sarah Silverman, the Publishers Guild, David Baldacci, and others for scraping their whole books and their whole repositories to train the foundational ChatGPT 1.0, right? So, I mean, it is what it is. Microsoft bought a lot of problems when it bought OpenAI, not the least of which is the fact that the LLM was trained on copyright infringed material, right? Mm. So, and you mentioned open source, and maybe we don't have time for a full exegesis on open source, but it's really not a copyright issue. If you want to talk about it, we can, but it doesn't solve the problem we're talking about today.
Yeah. Wow. We will definitely have to have you back because I think we just probably scraped the surface and hopefully rightly so. Got all the listeners exactly. Got all the listeners
very
thinking.
Nice. Very nice.
Well, so Richard, you've been presenting with Brad on this, and I know Brad kind of presented all the legal angle. Are there any practical nuggets that you have, or what are you doing now that you have a better understanding of this?
Well, right now, I'm all about training and awareness. So Brad and I are trying to just get the word out, talk specifically at this intersection of software development, writing code and other artifacts that go into products, and ownership. And actually, we've unburied another one here, which is not only is the risk that you don't own the code, there's a risk that you might have someone else's code in your code base. So there's a double whammy there. We are launching whoownsthecode.com, which has a lot of links for these court cases and some other things, as well as an assessment just to get people thinking about, are they even thinking about this? Do they have contracts? Do they have AI usage thinking in their contracts? And then, right now we're just trying to raise awareness. And most clients, most people we talk to have the same reaction you do, which is this can't be true. This can't be the case. And until there's federal court cases and case law or Congress, changes the copyright law, this is it.
Richard makes a good point. This is the law today. But if the laws change tomorrow and the Congress magically changes 17 USC, which is the copyright section of the code, and says scraping to train an LLM is a fair use under 17 USC section 107, then I'm wrong. And I'll be the first guy to say that I'm wrong. But Jeffrey, all I can do is tell you the law as it is today.
Right. At a minimum, you would think OpenAI would need to buy at least one copy of each book that they used.
Jeffrey, my friend, that is exactly what I've been asking myself since November of 2022. Why didn't they just pay a license? You've obviously gone into a bar or a restaurant in your life, Jeffrey, yes, and you hear music playing, yes. Okay. Do you know how the artist gets paid for that song being played, which is not completely illegally different from legally different than scraping, right? There's an organization called ASCAP. Have you ever heard of ASCAP? ASCAP causes bars and restaurants to send a check in once a month or once a year to pay Taylor Swift to play her song.
Right.
There are licensing models, Jeffrey, that fit this fact pattern. There's the CCC, the Copyright Clearance Center. Go look them up. CCC. All they do is license text, right? So why didn't Sam Altman go to CCC and say, hey, I want to fairly train this LLM. I'm spinning up this thing called ChatGPT. Here's $100,000. Let me train on your data. And CCC would have said, great. And we would not be here today.
Yeah. Interesting. Wow. Okay. Well, we will definitely have to take both of your offer for a deeper dive and have you back on the show. But this has been fascinating. I think all the listeners are right to think about this and look at their own situation, and maybe some contractors update their standard contract to formally address this and get some legal advice in doing so. And yeah, that sounds like a slam dunk. Immediately.
I would invite your listeners to go ask Grok. Grok is my favorite. I'd say go ask Grok, what is a quitclaim deed? It's QUITCLAIM, quitclaim deed. Say, hey, Grok, what's a quitclaim deed? And that will actually give them some language that they could probably pair it over into their outbound contract. No kidding.
Yeah, absolutely. All right. Well, thank you both for coming on the Azure and DevOps podcast and helping us answer or think about the question, who owns the code? I appreciate it.
Right. Thank you, Jeffrey.
Yeah, thank you.
My pleasure. My pleasure. And until next time, dear listener, keep shipping.
You've been listening to the Azure and DevOps podcast. You can find us on YouTube, Apple Podcasts, Google Play, and anywhere you get your podcasts. Visit our sponsor, ClearMeasure, at www.clearmeasure.com. And on behalf of your host, Jeffrey Palermo, thanks for listening, and may God bless you.